Afternoon, and thank you for joining us for an MP webinar covering FMLA, key steps to ensure compliance and mitigate risk of DOL audits. I'm Katie Kreider, Marketing Specialist here at MP. For those of you joining us on a webinar for the first time, MP is a full-service human capital management company. We offer a complete suite of products and services to support organizations through the entire employee lifecycle, including recruiting, HR, payroll, benefits administration, time and attendance, and compliance assistance. We support our clients with cutting-edge technical solutions, as well as proactive, reliable service and deep HR and payroll expertise. At MP, we are wired for HR and help our clients succeed by aligning their people strategy with their business goals. I'm excited to introduce your presenter for today's program, Paul Corrales. Paul has over a decade of experience in the HR consulting space, working with businesses of all sizes and industries. Paul and his team of certified HR professionals at MP assist clients with compliance, training, and full-service HR guidance and support. Just a few housekeeping issues before we get started here today. If you would like to submit a question during the program, please use the Q&A feature at the bottom of the screen. We will also be sending out the recording of the webinar later today, along with the slides. And as a legal disclaimer, this training is intended for educational and informational purposes. While we hope that you will learn a lot today, we are not attorneys, and the information should not be construed as legal advice. And with that, I'm going to hand the mic off to Paul.
Thanks so much, Katie. Welcome, everybody. Good afternoon. I'm looking forward to diving into this topic. It's been a little while since we've been talking about it, but based on some announcements from the Department of Labor that we'll talk about in a second, it's probably even more now relevant than ever before. So today's topic will be Family Medical Leave Act, or FMLA. So the pieces that we'll cover in today's session will just kind of be defining FMLA, who's subject to this as an employer, which employees could potentially be eligible to take FMLA leave. We'll talk about some of that stuff in terms of the DOL announcements regarding audits and inspections. We'll go over some statistics in terms of what kind of complaints come in or lawsuits surrounding FMLA. We'll go over in some level of detail the responsibilities that employers have when it comes to FMLA. In working with businesses, a lot of times we find that employers don't realize the onus that's on them and the responsibility that they have in terms of managing FMLA and more so potential FMLA situations. So we'll go over that. And then we'll go over some tips, just from a compliance perspective, the things you should check on, the things you should be auditing, and the things that you should have in your FMLA policy if you are indeed subject. All right. So in terms of an overview, FMLA is a federal law. It guarantees employees who are found to be eligible up to 12 weeks of job protected but unpaid leave. So obviously there's been a lot of talk from state to state as numerous states, I think Delaware is the latest, have enacted their own, usually called PFML or PFMLA laws. The main difference with those tends to be that through these state programs there is some level of compensation. The nice thing about the state programs is usually they're the arbiter for claims. They'll decide whether to approve or deny a claim. FMLA is different in a couple key ways. A, it's federal. B, it's just job protection. There isn't a pay component to FMLA leave. You're not on the hook for paying people while they're on FMLA leave. The government is not going to be issuing payment for folks on FMLA leave. And then third, and sometimes the tricky part, is that whether for good or bad, you as the employer are the person who is approving FMLA leave or denying FMLA leave. So you can imagine that's oftentimes what leads to lawsuits and challenges and complaints would be the decision made by the employer in terms of whether or not to grant the leave. To be a subject employer, as a private business, you'd have to have at least 50 employees for at least 20 weeks in the current or the previous year. So you'd look at this year, 2022, or last year, 2021 in this case. And if you had 50 or more employees in 20 weeks of that year, you would be a subject employer for FMLA. As for the employees, they need to have worked for you for at least 12 months and performed at least 1,250 hours of service in the immediately preceding 12 months from when they were starting the leave. In addition, the employee who would be eligible must work at a location that has at least 50 employees within a 75-mile radius. So especially now where employers and companies are so spread out, you could have an instance where you're a subject FMLA employer because you have 50 or more employees, but because those employees are so spread out, you don't actually have an employee who's technically eligible for the leave because they don't work, you don't have any locations that have at least 50 employees within a 75-mile radius. So just an interesting thing there in terms of maintaining compliance and who is and isn't eligible. A couple of exceptions to the subject employer rule. All public employers, regardless of size, are subject to FMLA, as well as elementary or secondary schools, whether they're public or private. So a small private school, even if they're under 50 employees, if they're elementary or secondary education, they are considered subject to FMLA as well. It's a specific carve out in the rules. So the main qualifying factors or reasons for leave entitlement are the birth or placement of a child for adoption or foster care, to care for a spouse, child, or parent who has a serious health condition. And that's a thing to take note of, especially when we talk about interaction between FMLA and state level programs. So the FMLA is very specific about which family members are covered and which are not, and it's a relatively short list, as you can see here. Many of the state programs extend the eligibility to other family members as well. So just something to be on the lookout for if you are in a state that has a paid family medical leave law in effect. It's also available for an employee's own serious health condition, and then any qualifying military related exigency as well. So a lot of times you get the question, what counts as a serious health condition? Because obviously employees in the course of their employment have all kinds of sickness and maladies and the like, and it's important to really understand the distinction for what could potentially be FMLA eligible. So the way that the FMLA and the Department of Labor define serious health condition is an illness, an injury, an impairment, or physical or mental condition that involves inpatient care, hospitalization, or continuing treatment. So if it's a one-off thing, something that can be treated via triage, first aid, and not require a follow-up visit, then that's probably not going to be considered a serious health condition. If someone's admitted into the hospital, or spends the night at the hospital, or is treated and then needs to return for follow-up treatment because of it, those things would generally qualify. Also, any incapacitation periods because of pregnancy or for prenatal care. So if someone's, say put on bed rest or certain restrictions due to their pregnancy, that would oftentimes count. Also, chronic conditions or other permanent periods of incapacity not related to pregnancy can also fall under FMLA. And really what they mean by incapacity is the inability to work or perform other regular daily activities due to the serious health condition. So if some of the major life functions are taken away because of the condition, then it's oftentimes going to be something to at least consider for FMLA. So it's really important that as employers, and we'll talk about it when we go over the tips, but that all of your management team, your HR team, anyone who's got some level of responsibility at the organization really understands potential FMLA request triggers. The reason for this is that something that a lot of employers don't realize, and that unfortunately has been kind of sussed out in the courts and through litigation, is that the way that FMLA is intended is that employers have an onus and a responsibility to offer FMLA leave to employees when they feel that an employee may be eligible for it, or may be on a leave that should count as FMLA, or may need a leave that counts as FMLA. So we definitely saw a big litigation trend over the last several years where the courts have found that employers have not taken sufficient action to offer up employees their FMLA rights. So it's really important that through the course of managing your workforce, when things like the stuff on the list here happen, that you're at least starting the FMLA process if you are indeed a subject employer. So if you become aware of an employee's medical condition and they're then unable to perform the job functions, the essential duties of the job, in accordance with their job description, that's a potential FMLA trigger. Pregnancy and any restrictions around the pregnancy, and certainly once the employee gives birth, definitely an FMLA trigger. If you have an employee who's hospitalized for some reason, when you become aware that an employee's family member is having some serious health conditions and the employee is needing to take time to help with those issues, or if there's a military related issue where someone's needing to miss time for anything that has to do with their military responsibilities or that of a defined family member. So again, you want to keep your eyes peeled for these situations, and if you see them come up in the workplace, you want to kind of hopefully have a process in place to have the conversations and start the communication process, just to at least explore or inform an employee of their FMLA rights should they wish to pursue it. Once you do your part, once you've sent out the necessary paperwork, maybe a reminder, when it gets closer to the deadlines that are set, you want to get that ball out of your court from a liability perspective. Obviously, you want to take good care of your employees and make sure that they're, if they're needing leave, that they know what's available to them and are aware of their rights. But, from a liability perspective, it's just really important that when you think something may be an FMLA eligible incident or situation, that you're treating it as such. So a lot of people just view FMLA as the time off that's needed up to 12 weeks. They take the time off in one chunk, and then when they're healthy and ready to be back, they come back. Unfortunately, as we all know, life doesn't always necessarily work that way. There is also intermittent FMLA leave on the table in certain situations. At times, as you can imagine, whether it's someone who's requiring, therapy visits, maybe someone with a chronic condition who is generally okay to work, but let's say they have really chronic asthma or, some other debilitating chronic disease that when certain things happen, when the weather is a certain way, or, they just have something come up that they may need time intermittently. It's important that that's on the table as well. You do, have the ability to work through medical professionals and documentation and fitness for duty and restriction reports and all of that to help guide that. But you do have to take into account and realize that there may be situations where people are kind of in and out a little bit. So that could be either separate blocks of time for a single reason. Again, let's say someone has an injury that requires physical therapy once a week. That time away for physical therapy could potentially be considered intermittent FMLA leave. It could also be a reduced work schedule for a while. So it might be that they usually work 5 days a week, and because of the doctor's restrictions or recommendations, that they say, hey, we only want them working 3 days a week or 4 days a week, something like that, or that there are restrictions in place where they usually work an 8-hour day, but the doctor doesn't feel they can work more than 5 or 6 hours in a day. The tough part about that, and the thing that's really important to keep track of to avoid not overextending yourself if you don't wish to, is keeping track of that time on a consistent way and a consistent method, because whether it's full blocks of time or intermittent, there is still that 12 week measurement. So even if it is intermittent, that doesn't necessarily mean that they have the protections of FMLA forever. You do want to be tracking the time, at least for FMLA purposes. Now, as you can imagine, there are all other types of laws and regulations that can coincide with this. Americans with Disabilities Act certainly comes to mind. So there may be situations where something's also considered a reasonable accommodation and may stretch beyond the 12 weeks of FMLA time. But for purposes of today's conversation and for determining when FMLA has been exhausted, you do want to be keeping track of time, even if it's in chunks. Also important to keep in mind that employees can use intermittent leave for their own condition as well as qualifying family members' serious health conditions. If they're a service member of the military or their covered family member is a member and they have a serious injury or illness, those are both allowable reasons potentially for intermittent leave. So, what are your obligations as an employer? Well, first things first, if you don't already, if you are subject to FMLA, you want to make sure that your federal labor law posters include the FMLA poster. It's just a easy thing to be able to check the box on to show that you're doing your part. On the flip side, also an easy thing to get dinged on if you are audited by the Department of Labor for FMLA purposes. Having that poster helps check that box. Sorry for the grammar there. There is an eligibility notice that you want to give to employees when you make a determination of their eligibility for FMLA. There's also a written rights and responsibilities notice that you want to partner with the eligibility notice. We can give you them when we send out the slides and the recording. We can send, not too long ago, I think it was last year, the Department of Labor updated some of the standard forms for these. When it comes to the rights and responsibilities notice, it's important that it includes the following items. As a rule, it's good to just use the most recent version from the Department of Labor rather than kind of crafting your own. It needs to have a statement of the leave period designated, so what the window of time is, and confirming that this is going to be FMLA leave entitlement. So that's where we see some litigation sometimes, that someone goes out on a leave. Either the employer forgot to talk about FMLA or assumed everyone was on the same page that it was FMLA, or didn't realize they needed to offer FMLA, and then all of a sudden they're in the midst of this leave, and it's tricky, and the courts have sided kind of on both sides depending on the circumstances, whether they can retroactively go back and count the leave already taken as FMLA, or if they have to start the clock once they notify the employee and get the paperwork in. So you want to make sure you're on top of this. You also want to define your 12-month period for FMLA. So employers do have some options here. You can use the calendar year and use those 12 months as your leave year. You can also kind of use a rolling 12-month measure from the time that the leave starts in terms of measuring your FMLA benefit year. You do want to make it clear about the requirements for the employee to provide certification, as well as their right to use any accrued unused PTO time. You do want to make it clear that they have the right to the restoration of their job, as well as not losing their health benefits and other benefits while they're on the protected leave. You see a lot of complaints and litigation around that, either not being returned to an equivalent position or something going wrong with their benefits coverage. You want to clarify what the arrangement is going to be for maintaining that health insurance. So some employers will ask that employees send in payments to cover their part of their benefits that they are currently subscribed to. Others will have them start a payment plan when they return to work. You've got options there. You just want to spell that out in the rights and responsibilities notice. And then any potential consequences of failing to meet the obligation. So that the leave may be denied if they fail to send in any required certification notices. If they don't return, any COBRA type implications or effects on the benefits, things like that. In terms of what the employee is responsible for, when applicable, obviously emergencies happen, and especially with something like FMLA, but when the leave is foreseeable, employees are expected to give at least 30 days advance notice to their employer, and as much as practical when something is an unforeseen event. Once their rights have been communicated to them and they understand that they may have FMLA eligible leave, they do need to put something in writing in terms of formally requesting that once they've been made aware of their rights, as well as what they anticipate the time off needed to be. Once you've done your part and requested the certification from the medical professional, the clock starts and the employee must be given 15 days to provide that to you. So you have to give them at least 15 days. This is an employer obligation. My apologies, not an employer's obligation. But one of the big ones that we run into a lot of questions about is just this whole, what does it mean that I need to return them to an equivalent position? Let's say they served a unique role. It wasn't something that we had a backup for. We had to hire someone else to do the job. This person has now been in the job for 2 months, 3 months, and the employee's coming back and expecting to get their job back. This is a touchy thing. Certainly understand the concerns from the employer's perspective, but it is something that is enforced and can get employers into trouble. So among the things that the Department of Labor or the courts look at when determining whether the position that someone's returned to is equivalent, first they look at the pay, at the most basic levels, the hourly rate or the salary, but also things like shift differentials, the opportunity for overtime, also benefits, making sure that those are equivalent as to when they left. Obviously, if open enrollment happened while they were gone and the benefits changed, that's a different story. But the real thing is just to avoid any claims that something was retaliatory. Also the work site, when it comes to the geography. So over the years, I've worked with businesses who have had multiple locations. And while sometimes a job might even, just be a location might be in the next town over, or sometimes even just in the same town on the other side of town, there have been cases where it's been determined that an employee returned to a different location, even if the proximity is fairly close, is not equivalent. Because you have to think of things like transportation. So if you have an employee who takes public transportation to work, let's say, even if you're moving them to, let's say you own a coffee shop, and have multiple locations, the coffee shop on one street might be on the bus line and the other coffee shop may not be, so it may not be seen as equivalent. Shift is another one. So if you're in manufacturing or other industries where you have different shifts, even if the pay is going to be the same, the benefits are going to be the same, they're coming to the same factory, if you're moving them from first shift to third shift because that's where you have an opening, that's not going to be considered equivalent. And then finally, just the opportunity for non-discretionary bonuses, other incentives, things like that. You want to make sure that when they return, they're entered into any programs or any opportunities to potentially achieve bonuses and things like that. So what makes this topic more relevant than in previous years and months? First, the Department of Labor did recently announce that they have a formal plan to increase and expand inspections and audits surrounding FMLA compliance. We'll go over into what their focus points are going to be in a second. Also, statistically, They log the number of FMLA complaints that the Wage and Hour Division receives each year. Last year, that number was 928. It was actually slightly down than some previous years. I think with the pandemic and more people working remotely and not having to physically travel to their place of work, that's one of many potential reasons why people did not necessarily need to take FMLA leave. But it's still a significant number, especially when you look at the amount of back wages awarded to people filing complaints. That number is actually slightly up from 2020. So the Department of Labor did order $1.4 million in back wages paid to folks who made FMLA complaints. As part of their record keeping and data collection, the Department of Labor also keeps track of what the topic or the reason for the FMLA complaint was. The top reasons are overwhelmingly termination, so terminating someone while they were on FMLA leave, refusal to grant an employee FMLA leave when they felt they were eligible for it, and then, as we just talked about, refusal to return an employee to an equivalent position. So those are the top three by far. As for the DOL audits and inspections, their areas of focus are going to be the following. A, making sure that employers' policies in their handbook or otherwise, when it comes to FMLA, are compliant and hit on all the pieces that they need to. B, that an employer's FMLA forms that they're using are current, up to date, and include everything they have to. C, that posting requirement, so the poster we talked about. D, looking at communication, so correspondence with people on FMLA leave or applying for FMLA leave to make sure that those communications are compliant. That the procedures that the company is following fall within the timelines and the requirements of the FMLA program. And then finally, that they're calculating the leave times correctly. So what are the keys to compliance when it comes to FMLA? First, whether it's FMLA or any other request, even if you're a smaller employer, you really need to sit down for a second, see where is this employee working, especially if you're a multi-state employer now. Are they working in a state where there is a paid family medical leave program that may apply? Do they work in a location big enough that would qualify for them for FMLA? If not, do you have a leave of absence policy in your handbook or otherwise that may be applicable even if they're not eligible for FMLA? All of those things you really want to factor in because it's really important that you clearly communicate both in policy and in correspondence that, what if any programs work in conjunction and at the same time. You don't want to be in a situation where you don't make it clear that any of these leave programs run concurrently, and then you have someone take 12 weeks off under the state program, and because you didn't communicate FMLA, they're then going to take 12 weeks of FMLA on top of it. So it's very important that your communications are clear with anything that could be concurrent. Once you know what laws are in place, you then want to look at the eligibility guidelines for each of those programs. Is the employee eligible? Again, with FMLA, they have to be working for you for at least 12 months and have 1,250 hours of service. That isn't necessarily the case with a state program. So it might be a case if, I'm sitting in Massachusetts at the moment and we have a paid family medical leave program. The state program does not require a year of service to be eligible for PFML. So they may not be eligible for FMLA. We'd probably want to communicate that to the employee, but at the same time, they may be encouraged to then apply for the state program. You then want to look at their reason for the leave of absence request. Again, especially if it's something like caring for a family member. If it's, let's say, a grandparent, again, sitting here in Massachusetts, that may not be a covered family member for the federal program, but might be for the state. And then again, just look through all of your policies, your procedures, your practices. As with anything when it comes to HR and HR compliance, you really want to hit in and make sure that you're being consistent above all else. Another thing that people will often get hung up on is just the leave and the pay and the compensation and the benefits and all of that. So um, it's really important that as a business leader, as an HR professional, you kind of separate the two, and you have your bucket of things that are providing benefits or providing compensation versus things that are providing leave and job protection. So again, many of the state family medical leave programs do provide benefits. A disability and short-term or long-term disability insurance policy would provide benefits, but not necessarily job protection. Any company paid leave programs or paid time off, again, covers the monetary piece, but does not necessarily provide the job protection. On the other hand, things like parental leave, FMLA, and state programs will have that element of job protection that you got to be very mindful of. As with anything like this, you want to have a heightened sense of things that could be considered adverse or retaliatory, because job protection is just that. So there have been cases where someone's kind of been on their way out the door. They've been disciplined for things, or things are uncovered while they're on the leave, and courts have been somewhat favorable to that. If something really bad is discovered about the employee's performance or actions that they've taken that would be terminable, those have generally been okayed. But again, we only know about those because they made it to litigation and there was a landmark court case. So at the very least, there are some big time legal expenses that go along with getting that verdict. So just want to be very careful, especially when it comes to the job protection aspects of these leave programs. So when you take a look, hopefully, at your employee handbook and your FMLA policy, and honestly, before we get into these pieces of what you want to have on the policy, first things first, you want to make sure, do we need or want to have this policy in place? So what I will say is, from time to time, I've worked with smaller employers in my past who may have gotten a handbook template or a copy of a handbook from another larger employer, and that employer needed to or wanted to have an FMLA policy. And this company that inherited the handbook didn't need to. They weren't large enough, but because they had that policy in place, all of a sudden they're now subject. So if you treat yourself as subject and have the policy in place, then you are a subject employer. So just want to be careful there and really ensure that you need to have that. There are certainly circumstances where someone might be close to that number or otherwise want to offer FMLA, and that's fine. But just make sure that you need to. But assuming you do need to and or want to, here are some things you want to make sure that your policy includes. Definitions of what the qualifying reasons for leave are. Again, your definition of the leave year, how you measure the 12-month period. The allowance of use of people's time off to provide some compensation, because again, FMLA is an unpaid leave. Any interaction with the state programs, especially when it comes to running concurrently with a state program. What the certification steps are, what that process looks like. Just mention of benefit continuation and what the general payment arrangement is for people who are out on FMLA. Restrictions on outside work while they're on FMLA leave, and requirements for a fitness for duty upon return to the job. In terms of the forms that you want to have kind of at the ready to dole out when you have a potential FMLA situation. A, the notice of eligibility. B, that rights and responsibilities notice. C, certification forms. And then finally the designation notice, where you kind of thumbs up or thumbs down your determination of whether someone has an eligible leave that they can take. It's also a really good idea just to have some templates put together for your standard FMLA certifications. These will need to be customized on a case-by-case basis as situations arise, but it's really great to have the general required language down and just make a few tweaks rather than having to reinvent the wheel. So definitely a certification communication, a notification when someone has failed to provide the documentation that they need to within the time frame. And then also one for while someone's out on leave, when their leave is coming up for expiration and the expectation for their return to work. And then finally, again, as I said at the top, to avoid any unnecessary exposures or liability, you really want to make sure that people with supervisory and management level responsibilities are properly trained on FMLA. So for those of you who are HR services clients of ours, we do offer FMLA training for managers and supervisors. If you're interested and you're working with an HR partner currently, you can reach out to them to schedule that. But some of the things you really want to hit on and make sure that they're up to date on: recognizing potential FMLA scenarios, following the proper procedures for documentation and timeframes, having at least a surface level understanding of the relevant state programs, how to properly calculate leave time, and then again, just much like with harassment, just making sure they're very mindful of not having any tolerance for anything that could be considered retaliatory. Again, I know it's hard. Some people take it very personally when someone goes out on a leave and leaves the rest of the workers high and dry and kind of struggling in their absence, but it's just really, really important that we avoid anything that could be considered retaliatory. All right, so it does look like we have a few questions here. Let me bring those up 1 second. If an employee is incapacitated, unable to work because of a workers' comp qualifying injury or illness, and they also meet FMLA qualifying conditions, are there expectations that FMLA and workers' comp leave run concurrently? Yes, so you'll want to definitely start the paperwork process. The doctors will fill in the necessary paperwork, but yeah, and it's, as I'm sure you can imagine, it's very difficult to terminate someone off of workers' comp leave, but I did work a case or assist from a consulting perspective with a scenario that was workers' comp, but the employee ended up being kind of on indefinite leave, but they did go through the FMLA motions to at least create that 12-week window. And as you would expect, we did need legal counsel to get involved and all of that. But yeah, if you have someone out on qualifying leave, you at least want to explore FMLA and kind of get that process started. Okay. If someone is clearly not eligible for FMLA because they do not meet the requirements, do you still need to require them to apply and give an official response, or can you skip that step if you are sure? So, it really depends on your risk tolerance here and, how picky you want to be in terms of compliance, but I do tend to recommend that employers do go through the motions, and in that determination document, it's very, you don't have to go through all of it, but you can give them the rights and responsibilities, and maybe even at the same time, just give them that determination notice to say, no, you are not eligible. And then the reason why would be, for instance, you haven't been working here for 12 months. If it's something as clear cut as that. If they're not eligible because of their time served with you, or that they're not in a geographic location, there's no need to have them go chase down their doctors, but it would be good to give them that determination notice so that if they make any claims against you, you have that on file, that you let them know that they weren't eligible and why. So let's say things go ugly and they lose their job and they go to a lawyer, and the lawyer, not knowing all of the circumstances, goes and files suit saying you didn't offer them FMLA. It's nice to just know that you did what you were supposed to. If a person is on short-term disability and it extends past 12 weeks of FMLA, should we separate employment? Great question. Definitely not automatically. Depending on what the circumstances are, you just want to be careful. Again, there is so many other rules and regulations that come into play, most notably the Americans with Disabilities Act. So there have been cases where the Department of Labor or the courts have decided that, a small extension of leave beyond the 12 weeks can sometimes be considered a reasonable accommodation. That being said, the courts have also made it clear that the ADA is not a leave law, It does not provide leave in and of itself necessarily. So again, if the doctor is saying, hey, they're going to be out for a while beyond the 12 weeks and we don't really know when, it's kind of indefinite, that may be grounds for you to be able to terminate. Again, that short-term disability insurance does not provide job protection like FMLA does. So it really depends on the circumstances, but I would say if someone's coming up on their 12 weeks and they have a doctor's note that says they need one more additional week or two more additional weeks even, or something like that, then that could be probably viewed as a reasonable accommodation, but it's really on a case-by-case basis. All right, let's see. Looks like we have some other questions here. Okay, so a question about adult children. So that's a tricky one. So when you look at the definition, maybe I can bring it up here, or at least I don't think I can screen share it, but I know that the FMLA regulations do define a son or daughter as a child, whether by biological means, adopted, or stepchildren as well. And also that I think it's loco parentis, which means like if they're under your guardianship, if they're like a child to you, that'll sometimes qualify too. But yeah, the cutoff is generally 18 years of age, but they do have a carve out for an adult child who's incapable of self-care, either for mental or physical disabilities. And I take it the question might be, does that mean that they have to have been, incapacitated before the FMLA incident? Or is this for, people who are born with, physical or mental impairment of some sort? In terms of how that's been interpreted, um, if the if the injury or if the incident is incapacitating to that adult child, they're generally a covered family member still, even if it wasn't, a something that they had before the serious health condition. That the serious health condition, if it's of the extent that they're incapable of caring for themselves, then that adult child would generally be a covered family member. All right. Employees often become irate when they see a colleague who is on FMLA leave, out and about, outside of their home, not incapacitated by their view, not bedridden. Um, can you speak to the scenario relative to the role that FMLA absent employees unable to perform essential functions of their job? Yep, I actually was talking to a business about this just this week. Um, has always been a thing, but as you can imagine, even more prevalent in the social media age that we're in now. So someone might be out on FMLA leave and all of a sudden you see them posting pictures doing something fun or in another city or on vacation. So there was one landmark court case a couple years ago that did side with the employer. Someone was out on FMLA leave and then, posting pictures from a tropical vacation somewhere. So I will say it's a very touchy subject. It's not a black and white subject. You really do want to factor in the circumstances, what the leave is for, um, what what restrictions they have because of their serious health condition versus how that relates to their job duties with you versus how it relates to their abilities to do the things that you're observing them doing outside of home. Um, if you're thinking of taking action against an employee on FMLA leave, especially for reasons like that, I would definitely recommend speaking with legal counsel just because it can be very treacherous waters. Um, FMLA provides them job protected leave. It doesn't necessarily require them to stay in a bed or stay at home or stay hospitalized. But again, sometimes the court have ruled in ways that have surprised me and sided with employers in situations like this. So it's not out of the realm of possibilities that you have a case and can take action or even terminate someone based on their actions while out on FMLA. You just want to proceed very cautiously with that. If we are a company that does not have 50 employees within a 75-mile radius, do we need to have the poster posted? We do allow employees to apply for FMLA. Yes, yeah, I would say yes. If you have one of those all-in-one posters like we provide businesses with, one of the squares on the all-in-one federal posters is generally that FMLA notice. So I would say yes, it's good to have that up because you are a subject employer, and part of those requirements as a subject employer is to have that posted. If an employee was full-time and changed to part-time, can they take FMLA if they've worked the subsequent hours in the measurement period? Yeah. Yep. So they would be eligible for the leave. Yes. If a father has a new baby and wants intermittent leave for baby care and doctor's visits, can they have it? That's a little bit trickier. I will definitely defer to state programs for that, especially. So if you're in Massachusetts like I am, the state provides bonding leave for both parents when a child is born or placed. So there are things like that to factor in. In terms of whether something like that would be eligible for federal FMLA, most likely not if it isn't a serious health condition. Obviously, if the baby or the mother has complications in childbirth, or there's complications with the birth, a birth defect, or something serious, that could definitely be an FMLA scenario. If it's more routine, not necessarily. Let's see. Would you request a certification to someone who is pregnant and requesting a leave of absence due to pregnancy? When should you request, before the child is born or after the child is born? So it's good to get that squared up again, 30 days ahead with that notice period. Yeah, if they come to you and say that they have some restrictions or some special requirements, again, you do want to be mindful of state laws and pregnancy accommodation laws in terms of what you can make assumptions for and what you can do in terms of restrictions. But if there's any speak about complications to the pregnancy or time missed or requests for accommodations, it wouldn't be a bad idea to start the certification process. So it looks like those are the questions that we have for today. Thank you very much. These were great questions. I hope I answered them adequately and to your liking. Again, we will send over a copy of these slides. We'll send over some of the FMLA paperwork. But with that, I'll hand things back over to Katie.
Thanks, Paul. Lots of valuable information on the FMLA audits. The MPHR team is here to help guide your organization on any HR compliance issues. If you would like to learn more about how we can assist your organization, please visit our website to set up a short 15-minute call. Be sure to join us on June 2nd for our webinar on unpacking the employee retention credit, funding for businesses impacted by COVID. Visit our website to register and see the full calendar of upcoming events and available resources. We will be sending out a recording of today's webinar with the presentation slides this afternoon. Thanks for joining us and have a terrific day.